Welcome to Law Sessions. I'm Jennifer Housen. In this session, we will explore freehold covenants. In an earlier session, of course, we've looked at leasehold covenants, but in this segment, it is all about covenants between freeholders. Now, this segment concerns promises that are made between freeholders of the land in relation to the way they use the land. Now, if you go back to the introduction and certainly to when we considered certain terminologies in land, if you remember, freehold looks at the best ownership right you can have, which is a fee simple absolute in possession, and so you're a freeholder. And the idea is what happens when, for want of a better terminology, I own my house. Then I'm a freeholder and I own my house and you own your house. Can I restrict the way you use your land, for example? So, freehold covenants often arise where a person sells the freehold in part of his land, but he wishes to restrict the way that the land is used afterwards. So, for example, let's say I sell you part of my land. So, let's say I sell you the garden, for example, of my land, because let's assume I live on a 2-acre piece of land and I sell you the back garden, which is 1 acre. Well, the possibility is that I may very well not want you to build a high-rise apartment building on that piece of land. So what I would then do is, within the conveyance, is to ensure that I restrict what it is you can do with the land. Because let's say, for example, you want to build a factory and there are smells coming from the factory. Again, I may want to restrict that. Now, we don't have a problem, or this may seem all very well and good as between the original seller and purchaser, since the promises themselves are enforced as a matter of contract. But what happens if each piece of land is then subsequently sold to a third party? Well, clearly, there is no privity of contract between such persons. Now, it has long been possible for the benefit of a contract to be assigned to a third party, but the courts would not allow the burden of a contract to be assigned. So, most of what we're looking at here in regards to freehold land, as I said, is where, for example, I own Blackacre and Whiteacre, or before it was Blackacre and Whiteacre, it was just simply Blackacre, but I've divided it, and let's say I call the gardens Whiteacre, and I sell Whiteacre to you. Well, the fact is, between you and I, we have agreed that we will place certain restrictions. You've accepted it, you being the covenantor, and I've gotten the burden of it, me being the covenantee. But should that continue, if, for example, I sell my portion, which I continue calling Blackacre, or you sell your newly acquired Whiteacre, why should it be that it continues to bind any subsequent purchaser? Now, if I take you back to contract law and privity of contract, if you remember, there are certain exceptions to privity of contract. And one of those exceptions, of course, is precisely the area we're looking at, which is there may be covenants and certainly the way parties deal as between each other in relation to covenants, which may take it outside privity of contract. Again, land law is very special in that it is a special type of contract, and as such, because it is real property, it is the type of property that is unique, there are rules as relating to land contracts which certainly do not relate to any other type of contract. So what we will see here is that notwithstanding privity of contract, there will certainly be benefits and burdens, issues as relating to parties who are not in privity, which will certainly be enforceable, albeit that there is no privity as between parties subsequently. Well, in the 19th century, the courts of equity allowed the burden of covenants to be attached to the land, because the idea was that traditionally and historically you could get the benefit, but the burden unfortunately wouldn't pass. So as I say, equity has allowed this so that certain covenants which are attached to the land will pass on so that they affect anyone who then acquires the land. Now, originally equity enforced both positive covenants, and positive covenants are covenants that require the owner of the land to do certain things, for example, to maintain a common fence that run between two properties. Now, here's a distinction. Positive covenant usually requires the owner of the land to do something, as opposed to negative or restrictive covenants, which is what we're dealing with here in freehold covenants. And these type of covenants are covenants that restrict the way the owner of the land uses his land. For example, not to use the premises for business purposes. Now, if you ever want to have in your mind a clear distinction of a positive and a negative covenant, you tend to find that a positive covenant, as I said, requires you to act, and in acting, sometimes to spend money. But here's one way of knowing if you're dealing, for example, with a negative covenant. If you can, for example, lie in your bed and do nothing and comply with the covenant, it is a negative covenant. So if it says, do not build a high-rise block of flats on the land, if you lay in your bed and did nothing, you would comply with the covenant. And that makes it a negative covenant. That is one way, for me anyway, to remember it, because it allows you to understand that as we go in further, you will see there are certain times when a covenant is drawn negatively, but it has a positive impact. For those of you among us who do maths, of course, think of the double negative. So you will not do something will certainly mean that you will do it. So positive covenants used to not be enforced, but now, used to be enforced, but now we see, as it relates to restrictive covenants nowadays, it will only be enforceable if it is a negative covenant. So we've seen this is what has happened over time, in that equity says that when you're looking at a restrictive covenant, it tends to be negative in order to be enforced. Now, since covenant only exists in equity, then of course it is going to be vulnerable to all sorts of issues. Now, as we have seen, and as I have mentioned, you are required to, for example, ensure that any equitable interest you have is protected. A covenant is always equitable. So restrictive covenants have to be given appropriate protection. And of course, we will touch on this closer to the end of the session. Now, in relation to the remedies used to enforce restrictive covenants, such as injunctions, again, these are based in equity. And because we are looking at an entirely equitable framework, then it is all about discretion, which, unlike the common law remedy of damages, is available as of right. It is not available as of right, and as such, because it is discretionary, you have to ensure that the maxims of equity, you meet them. The case that first established restrictive covenants, of course, in freehold land is that of Tulk and Moxey in 1848. It is a case that I will urge you that you read and ensure you understand not only the facts, but the points coming from it. Now, the rules relating to restrictive covenants depend on whether one is looking at whether the benefit of the covenants have passed to a successor in title, or one is looking at whether the burden has passed to the successor in title. We have seen that the common law would allow the benefit of the covenant to pass to the successor, but equity followed the law here and largely adopted the common law rules. So both at common law and in equity, we would see the benefit passing. However, in deciding whether the burden would then pass or run to a successor in title, equity developed its own rules. Thus, this particular area of the subject can become a little bit complicated, since there are two sets of rules, the common law rules and the equitable rules that have to be followed. Because within the common law rules, we see that the benefit will run at common law, the benefit will run in equity, but the burden only ever runs in equity, because at common law, it will never run. Now let's just get clear on a few definitions that we have to encounter as we go through this session. First of all, covenant itself. Well, a covenant is a promise contained in a deed, and it's usually in the transfer or the conveyance of the freehold estate, though it may, of course, be in a separate deed. The covenantor is the person who makes the promise. The covenantee is the person to whom the promise is made. So, of course, if Blackacre is sold to, if the owner of Blackacre sells Whiteacre, then the person on Whiteacre who has agreed that he will not build, for example, a high-rise flat, will be the covenantor. And the covenantee, of course, would be the owner of Blackacre who is getting the benefit. He's the one who said, you will not build a high-rise building on Whiteacre. So the covenantee is the person seeking to enforce the covenant. When we speak of the dominant tenement, this is the land owned by the covenantee. This is the land which has the benefit of the covenant. And the servient tenement, this is the land owned by the covenantor, and this is the land which has the burden of the covenant. Positive covenants we've touched on already, and a positive covenant will require the person making the promise to positively do something. So, for example, to act or maintain or repair. A negative covenant is a negative restrictive covenant which will require the person making the promise not to do something. So, for example, not to use the property in a particular way. Now, freehold covenants can be seen by some as a private control of land use. And this involves the landowner seeking to regulate how the land is used even after purchase. Now, the arrangement which people make to take the form of covenants will not only have an effect on the parties entering into the arrangement at the time, but also it will have an effect on the successors in title. And a covenant is simply a promise contained in a deed, a promise within a contract between two contracting parties, which is elevated to the position of a covenant if it is made under deed. Now, again, if you remember, if you do something by deed from contract law, it does not necessarily have to show any sort of consideration. And in fact, you will see that when you look at the covenantee, he doesn't necessarily give anything. It is the covenantor who says, I will not build a high-rise flat on my land. The covenantee does nothing. He's the one who's taking the benefit. So again, precisely because it is a covenant, precisely because it is unlikely to have any consideration attached to it, it needs to be under deed. It is described as an undertaking of one party which will act as an encumbrance on his land and which will benefit the land of the other party. So an example of a promise under a covenant of freehold land is a promise to keep a roadway leading to a property in good order and repair. Now, landowners are perfectly free to enter into any contractual relationship they see fit with regards to the sale and use of their property, providing the other parties are happy with it, happy to enter into it, and have signed up to it. Now then, we will pause there, and when we come back, we will consider further some of the issues in relation to freehold covenants and see how this area actually operates in practice.